Today's topic is something a little bit off the beaten path. It's not something we face normally, but comes to my attention because earlier this week, Brad and Angelina apparently going to be going through a divorce. And unfortunately, neither of them called me. So if you're watching this expecting me to talk about their divorce, it's not going to happen. It may have something to do with the fact I'm not a California lawyer. But I'd like to sort of take that example and talk a little bit about the so-called celebrity divorce. We don't get a lot of them in Wisconsin. We don't get a whole lot of celebrities around here. But over the years, I've been fortunate enough to have represented some people in which there is some sense of a media interest in the case for one reason or another. I've represented several professional athletes in the various sports in the state, and sometimes the wives of those athletes. I've represented a couple politicians in different forms and a couple other people who are well known. And I've developed essentially 3 pointers that I'm going to make in this presentation that I believe very strongly, if you're ever fortunate enough to have a celebrity divorce, even if it's lower than the level of Brad and Angelina. The first is stay out of the media. It is really exciting and fun, and I'll use the term sexy, to get a call from the press. And the immediate knee-jerk reaction of anyone is, boy, I want to see my name in ink. It'll make my wife or husband proud of me, and make my parents realize why they helped pay for law school or whatever, and they'll be proud and talk to their friends about it, and just fun for me to see my name in ink. That may be more true in other areas of law, I don't know. I can't imagine it in divorce. And when I've represented people where the media is going to have an interest, none of them have wanted the case litigated in the media. And when I've talked to them about possible media presence, the response I've gotten each time is, if you can avoid the media entirely, fine. If not, minimize it. So on the few occasions where I've gotten calls from the media, I don't use the term no comment, because that sounds like I'm hiding something. So I've made sort of a very bland comment about this is a sad proceeding, and the parties are hoping and wishing to work this out as between themselves, and they would appreciate privacy while doing so. And that's basically it. That it's a private proceeding, that they're sad about it, and that they're going to try to work it out. Litigating it through the media, I don't think helps at all unless you're trying to impress your client, because it certainly isn't going to convince any judge, and most judges that I know I don't think appreciate having lawyers argue their case through the media. So if you can avoid the media entirely, fine. I've had a client once where was representing whose husband was a professional athlete. Media was present in court. She said, Greg, if there's a back door, use it. And much as I would have loved to have gotten on TV and made some comment, it was possible to go out the back door, not have to make a no comment, and not comment at all on the case. I don't think it makes us look good as lawyers to do so. And I don't think that getting on TV and arguing our case is effective, and I don't think it's good either for the profession, and certainly not good for our clients. Second tip's an obvious one. I already mentioned it, but I'm going to go through it again, which is resolving the case, and it's consistent with the first one, which is try to reach a resolution as quickly and easy as possible. And here's something that I've done, I believe, twice in my legal career, maybe a third time, but it's rare, but I have utilized it. In Wisconsin, there is a 120-day waiting period between the beginning of a divorce and the time the court can grant the divorce, absent an emergency. On a couple of occasions where there's going to be media attention, or could be media attention, we have resolved the case before filing. In other words, both sides have gotten attorneys. We've exchanged information. We're not going to do formal discovery anyway, so we did all the informal discovery, negotiated the settlement, and then waited our 120 days for the final divorce hearing. There's a risk in doing so, of course. The risk is that Wisconsin law provides that while Agreements in anticipation of marriage, like a prenup, are presumed valid. Agreements in anticipation of divorce are not until approved by the court. We don't have time in this video to get into it, but I think that law has it backwards, actually, and that people who are negotiating an agreement knowing that a divorce is upcoming should be entitled to have that agreement presumed valid if they both have lawyers and know what they're doing, but the law is what it is. And therefore, the risk is that during that 120 days, either party can back out of it. There are things lawyers can do to protect that if they want to, but they may or may not be successful in terms of doing so. The problem with doing the pre-filing agreement is that both parties must agree that the marriage is really irretrievably broken. And we see a lot of cases where one party is hoping to reconcile, wishes the divorce wasn't happening, or dug their head into the sand, what I call the ostrich approach to divorce, and pretend it's not happening. But if there's a case where both parties have accepted the fact that the marriage is over and it's just a matter of negotiating its final terms, and if there's the possibility of any media coverage, it makes a nice approach to be able to tell the media that the matter has already been resolved and you're just waiting for your final hearing date. Let the 120 days run, get in on the 121st day, and get the divorce done. And it can work very, very effectively in terms of the media contact being equivalent to the accident. There's nothing to see here. Move along. The third point is that under any circumstances, remember, if you're in one of these cases and the media does contact you, that there's any form of press or any form of publicity, that if the parties have children, that they may read or hear what is being said, and if not now, maybe later as adults. Years ago, Milwaukee Magazine used to do an issue where they rated the judges, and it was tremendous fun reading it, because some lawyers under anonymity could then trash judges, of course, publicly with our names. You only say great things about what a wonderful judiciary we have, and we do. But there are exceptions, and it was always fun to read lawyers anonymously trashing one judge or another. And I was talking to a judge once after it, and the judge said, for myself, I don't really care. Nobody's going to run against me in the next election anyway, and everyone's entitled to their opinion. But my kids read it, and it's difficult to tell them what some lawyer under cloak of anonymity is saying about me. That is one thing, as bad as it is having children read what some anonymous judge said. To read what their mother said about their father, or their father about their mother, whether it comes from them directly or through a lawyer, is really not a good thing and doesn't help the children. As one child said, was quoted as saying that whenever mom criticizes dad or dad criticizes mom, I feel they're criticizing me, because half of me I feel is mom and half of me is dad. So when lawyers start publicly trying their custody case by attacking the other party, as I said, I don't think it does any good. I don't think it impresses the judge at all. It may in fact be a negative and turn off the judge. But I think we need to keep in mind as lawyers that if there are children involved, and they can be older children, they don't have to be younger children or even adult children, that they're affected by the divorce, and that anything that happens in an aggressive nature, in terms of attacking their parents, the child can be viewed as attacking the child, his or herself. So we don't get a lot of these cases. When we do, they're fun, they're exciting. We want to go out and tell everyone. When the media calls, we want to get our name on the paper, we want to get on TV, want to watch ourselves on TV. Fight the instinct. We're professionals first. So the first thing is try to avoid the media if you can't, minimize it, and any comments should be generic, and they should be broad, and they should be peaceful sounding. And actually, I think that's much better for our profession anyway. Second, the case needs to be resolved. If you can do it ahead of time, great. If not, a private resolution is absolutely essential in these cases. And then third, remember that in addition to your client, that if there are children, if the parties have children, that they're affected, and that what you do that may impress your client temporarily, in the long term, hurts your client, because if the children are hurt, the parent is hurt as well. So with that being said, Brad, Angelina, if you're watching this, it's 414-272-5632. Waiting for your call.